We see a lot of reports where a lawyer fails to take a step that needs to be taken in a matter, or just forgets or doesn't get around to doing it, and that can cause problems. Sometimes, even if the lawyer gets around to taking this step eventually, it still causes problems due to the delay in taking it, as in this example of a wills and estate claim that we received. In this case, our lawyer had acted for a long time for an individual who had passed away. The deceased estate consisted primarily of shares in a publicly traded company I'll call Company X, that at the time of the death of the deceased were worth several hundreds of thousands of dollars. Now, the personal representative of the estate was the sister of the deceased, and most of the beneficiaries were charities. The charities preferred to receive their bequests in cash, so the personal representative had to have the estate probated so the shares could be transferred into her name and she could instruct the broker to liquidate them. Hence, she instructed our insured to probate the estate. Now, our insured was a sole practitioner, and he had a very limited wills and estates practice, and so his support staff was not versed in preparing probate documents. To make the matters worse, our insured was preparing for an impending lengthy trial, but nevertheless he took the retainer, feeling that he could get around to probating the estate in due course. After he finished the trial, not surprisingly, he had a number of pressing, urgent matters that had backed up, so again he put off attending to probating the estate. Then he forgot about it, and when he remembered, he simply put it at the bottom of his file. Now, you'd think that somebody would be pressing him to move forward with this, but in this case there really wasn't a squeaky wheel. The personal representative, the sister, lived most of the time in Arizona in her second home, and she wasn't receiving any money, so wasn't pushing the matter. And the beneficiaries were, of course, charities, i.e. institutions that weren't saying, show me the money, and we're just waiting for the estate to be probated in due course. Now, eventually our insured, after many, many months, got around to probating the estate. But as it happened, just prior to filing for probate, the fall of 2008, huge stock market crash occurred, with the result being that the value of the shares in public company X went down from approximately $250,000 to just a bit more than $50,000. On the face of it, a big problem. Now, fortunately, this all worked out as the charities were sympathetic. They agreed to take the shares in kind, and after several months, the share values returned to their pre-recession values, and so no claim was made. It doesn't always work out this well, so the lessons to be learned from this is that be careful in taking retainers where you won't necessarily have time to attend to the steps that need to be taken. And don't necessarily think, well, there's no limitation period or other procedural deadline that I can't make, because it may be, as in this case, and as it is often the case in difficult economic times, there can be external factors that you can't even foresee that could impact your client's position as a result of the delay. So don't take a retainer that you can't attend to all steps necessary in a timely manner.